Step number 5, maybe this is the best phase of the process, is distributing out the money. So you've gone through steps 1, 2, 3, and 4. You're at step 5. Now it's time to distribute the money out. How do you do that? It can be easier or it can be more difficult. It's easier if everybody is on board. So let's say at the end of the process, there's 3 kids, there is $300,000 in the bank account. Everybody's going to get $100,000 from the estate account. You heard me say estate account. That's part of the process, is that when you're marshaling and gathering up all the money, you take it from mom's bank account and you put it in a new estate account. You need a new tax ID number to do that. So you've done that. You've got $300,000 in the bank account. Now it's time to distribute it out to you and your 2 siblings. Great. If everybody is in agreement, what they'll do is they'll sign a receipt, and the receipt says, I'm getting all the money that's coming to me. And if you get everybody to sign that receipt, then you can give everybody their checks for $100,000. The money is distributed out. It's done. It's pretty easy. Where there isn't that kind of agreement and cooperation, and somebody says, oh no, you owe more money, or mom had more money, show me the inventory. That makes it really hard to do it yourself probate at that point, because you know that people aren't getting along, and likely they're going to lawyer up, you're going to need to lawyer up. And that's means you take it from do it yourself to, oh no, this is a litigated probate. So hopefully that doesn't happen. If you don't get agreement, then there is a formal notice process that you go through so that you can distribute out the money. Again, you hope that that's not the situation. Now, I didn't really talk too much about the will should say where the money goes. If there is no will, the laws of intestacy say where the money goes. If mom was a widow, she only has 3 kids. The laws of intestacy say that the 3 kids inherit. What if one of those kids didn't survive mom, but they left 2 kids? Then that deceased child, their 1/3 share goes down to their 2 kids. So the laws of intestacy, when there's no will, it does make it a bit more complicated, especially if you're trying to do it-yourself probate. Do you have to do a Form 1041? That's an estate tax return. It really depends on what the assets of the estate look like. If mom's assets were such that, hey, they're investment accounts and that they are generating more than $600 in income to the estate, there might need to be a 1041 filed. We always recommend when we're working with clients to use an accountant to make sure that the right tax forms are filed, because if you don't file the right tax forms, there are some big penalties that the IRS imposes. Next question is, if there are no debts, can step 4 be skipped? You mean you don't do notice to creditors? You can skip notice to creditors as long as you're willing to accept the risk that maybe you were wrong, that there weren't any debts. But my caveat to that is, as long as you make sure that the IRS is paid. That's a critical piece to make sure you're not dealing with a tax liability. So this kind of goes to the distribution of assets and whether how you can protect assets. So the question is, if there's a special needs trust for a disabled child, is that protected from financial recovery entities? The answer is that if the decedent owed money, then as a general rule, the special needs disabled child, that their inheritance might have to pay whatever is owed to the state agency, for example. But, and this is a very large but here, is that let's say that the amount owed to the state agency is because of Medicaid. Well, in that event, assets that go from a Medicaid decedent to a special needs child or special needs trust, no, those are exempt from state recovery. So definitely, if you're dealing with anybody that's been receiving government needs benefits, either decedent or the child, talk to an attorney, because there are definitely exceptions to the rule that the state has to be paid back. For example, special needs trust child doesn't have to have their inheritance impacted by Medicaid benefits that mom receives? So great question. So it's a little bit more complicated, definitely than do-it-yourself probate, but it's great questions to be asking. And then if the beneficiary of an estate, what if they're in a nursing home? Then it would have been really important that the decedent set up in their will a trust for the person who is in the nursing home, because in that way, the person who is receiving, the person who's in a nursing home, if they have a trust created by mom's will, then they can stay on their benefits, but still get the money because the money is in a trust, and it doesn't therefore interfere with their benefits, doesn't knock them off benefits. The state will never get those benefits ever, get any of that money, yet they'll still pay. So setting up a special needs trust through a will is a really great estate planning tool. Oftentimes though, we find that mom's will didn't do that, and then the person is in a nursing home who's inheriting from mom. If they're under age 65, you can set up a special kind of trust. It's called a D4A trust, so they can stay on their benefits, but a D4A trust does have state recovery. So just by a little bit of good estate planning in advance, you can ensure that there's no payback to the state. Great questions. Now, if the decedent owned property, not just in Washington, but in Idaho and maybe some other jurisdictions, then what? Well, there has to be an estate administrative process in each of those states. So as a part of people's estate plan, let's say that they own property in California, Idaho, and Washington. Well, we're going to be talking with them about making sure that their California property is set up in a revocable living trust to avoid probate there, because probate in California, I am told, is terrible and expensive, whereas probate in Idaho and Washington is really simple. We often do probates in Washington and an ancillary in Idaho, and it's very easy to do. But the more complicated somebody's estate is, the less likely that you're going to do a do-it-yourself probate, because it just gets too complicated. So, just keep that in mind.